Okay, welcome back, everybody. We're in week 3, and we're going to talk about the sources of law, but we're also going to talk a little bit about legal briefs and how they are constructed, because it's something you will do a fair amount of the remainder of the course. So I want to make sure we're on the same page on that. But before we get into week 3, let's go back and talk a little bit about last week's discussions and some of the pitfalls I think that we can learn from. So last week's discussion, I asked you to take a law that had to do with the workplace and to give me a fictitious workplace, be it a retail or a factory or whatever you wanted to choose, and tell me how, looking through the lens of a security manager, that law may cause you to take action. And one of the things that happened was a lot of people fell into a certain trap, and that is that they read the law and then told me about all the things they're going to do to comply with the law. And I think the one that was used, I think by most, I won't say by most, but used the most, there were two really, one about OSHA and one about shoplifting. And the shoplifting one was very telling because people described the law and then they said, I'm going to set up cameras and I'm going to train my people on how to confront. But the question really was, as a security manager, what must you do? And if you think about those shoplifting laws, if you read them through, they describe what constitutes shoplifting, what the penalties are for shoplifting, but they don't have any prescribed requirements for a retail establishment when it comes to shoplifting. And by that I mean, if I have a retail shop, let's say I have a jewelry store, and I decide that I'm just not going to do anything about shoplifting, I'm fully within my right as the retail owner and the owner of the retail goods in that shop to do nothing. Now, that might be silly, and it might sound silly to you. You're not going to let people just come in and steal your diamonds and walk out. But I put it to one student in the discussion in this way. If I have a customer who comes in and buys jewelry from me on a regular basis, in the course of a year they spend $50,000 on jewelry. And during the course of that, I see them grab some jewelry cleaner, which I have on the counter, and just pick it up. And it's $10 for the jewelry cleaner, and they put it in their purse and they walk out. They don't pay me for it. They don't say anything. Am I going to call the police on that person and give up $50,000 in sales annually for a $10 item? And the answer is clearly no. From a business strategy standpoint, no one would do that. I mean, I guess you could, but it would be to your own detriment. The law doesn't require me to turn that person in. It doesn't require me to detain them, to wait for the police and to have them arrested, to swear out a complaint. It allows me to make a decision. Now, with safety equipment, in some cases it said that I need to make people safe. And you need to understand that there are certain things in each law that are requirements, that things you must do that are specified in the law. If not specified in the law, then your actions may be simply to do nothing. And that is always an option. And as a security manager, you need to weigh the consequences of action versus inaction in some cases. And in some cases, inaction is the better option. In the case of the jewelry store, inaction on the theft of a $10 item in order to preserve $50,000 annual in sales may be an inaction that you simply say, this is a good idea. In fact, when they come in, every time they come in and buy something, I would hand them some jewelry cleaner and say, don't worry about taking it off the counter anymore. I'll just give it to you. We can't overcompensate because in some cases it can cause a liability. Think about OSHA says that anybody who enters a construction zone may have to wear a hard hat, right? Specifies, safety equipment, an administrative law in a certain area may say safety equipment to include safety glasses and hard hat must be worn in construction areas. If I have contracted guards, does that mean that I'm going to step up and get them, and they have to go in a construction zone, and I'm going to get them hard hats? Perhaps not. I would instead tell their employer, that's a construction zone, they can't go in if they don't have hard hats, you need to get them hard hats. The reason I might do that is if I give them a hard hat and it's defective and it doesn't fit right and they get hit with something and it causes them injury, I take on the liability. I've overcompensated by taking on giving that safety equipment out myself as opposed to have someone else whose responsibility it is to do it take it on, and therefore created liability. Focus your lens on mandatory actions and mitigations, the things that the law requires you to do, as opposed to the things that are standard to do. Yes, as a security manager in retail, I would expect that you would want to put up cameras and train people on how to handle a shoplifter. But the law does not require that you do so. And the first thing you should say is, I can do nothing and still be legally compliant. Then from there you build, what should I take on and what exceptions should I make in the interest of my business? So I hope that made sense to you. Think of the law as telling you what you must do. Start at that place, and those are things you must do and you must comply. You don't have an option. But anything you do above and beyond is optional, and you have to weigh the good and the bad against it. So this week we're going to talk about the sources of the law a little bit more, very, very briefly. We'll discuss the Federal Register, which some of you may or may not be familiar with. We're going to talk about case law, and case law is like the Wild West. It is really hard to keep track of. It's very fleeting and very eluding when you try to nail it down. We're going to talk about the IRAC formula for writing legal briefs, and then how to write a brief for this class, which is going to be a slight variation on what you read in the reading for this week. Okay, next two slides, very basic civics lesson and something you all know, but let's put it in perspective. The executive branch creates administrative law. It's published as regulations or executive orders and directives. So we all know the president can sign executive orders. The new president has done that several times in the first few weeks. Presidents are entitled to do that. They're entitled then to assign people to apply the law and to make administrative rules. The Environmental Protection Agency, the Department of Homeland Security, make rules that become law. You are required to be screened before you get on a commercial aircraft in the United States. It is a law. You must go through the TSA checkpoint, right? You can't just go and walk around the fence somehow and get on the airplane. That would be breaking the law. And there's an administrative law. The executive branch has empowered the Department of Homeland Security through the Secretary of Homeland Security to make that determination as to what's the best thing to protect people on commercial aircraft. That's the best he came up with. I don't know whether it's good or bad. You be the judge. But they're allowed to make those rules. The executive branch does that, and those administrative rules are very important to us in the security realm because there are many. On to the legislative branch. Legislative branch creates laws and called statutes. They pass and publish those as statutes, and you know that the Congress makes law, right? That's, your basic civics lessons. The Congress makes law. These laws are generally wide-focused. They don't get too descriptive in their laws. They may seem so when you read them, but they pass a law saying it's okay to collect income tax, and then the administrative side, the IRS, talks about how they implement that law. That's where our tax code gets to be volumes and volumes. But the legislation on income tax is fairly basic. States, counties, cities, towns, in Pennsylvania boroughs, they legislate too. They make their own rules, but it's commonly they're applying federal statutes in some form or another. So the state makes a law based on the federal law, and then the county makes their own law based on the state law, and then the towns and townships and boroughs make their own. They're using their police powers, as we discussed last week, in order to tailor the federal law, staying within its confines, to the norms and values of their own communities. So we have a lot of legislative law. We have a lot of executive orders and executive directives coming from the president, and then those branch out into these myriad of, normally 3-letter names across the government that makes up all of these rules. And how can anyone in their right mind keep track of all of these rules? So the main way that we keep track of administrative laws and legislation is through something called the Federal Register. I don't know how familiar you are with the Federal Register, but it is published daily, Monday through Friday. I went and checked yesterday. Actually, it was the day before yesterday. And the Federal Register was 132 pages for that day. And in 2020, there were more than 60,000 total pages of the Federal Register published. And the Federal Register simply tells you about rules, proposed rules, and public notices. It is, I call it the newspaper of change, because when you look at the Federal Register, you will see, there'll be a rule change proposed on the scheduling of marijuana as a Schedule I narcotic. proposed rule says we're going to deschedule it. It's the first step to legalization, and it's something that's probably coming in the next several years, as we all probably know. That proposed rule change would pop up. A public notice that the government was listening is seeking comment on a particular law that's been proposed. A new rule has been adopted after conversation in committee and all the steps that you learned in junior high and high school of getting a law passed. Once the new rule comes in effect, it gets published in the Federal Register. All administrative law changes, all executive and legislative changes get published in the Federal Register every day, Monday through Friday, 52 weeks a year, rather, and that's 60,000 pages in 1 year alone. Nobody really reads it. Now, I say no one really reads it. I don't think anyone reads it cover to cover. Certainly not me, but I am responsible for much of what I'm responsible for would have been published in the Federal Register. You need to have sources to help you digest and report on the Federal Register rather than try to rely on reading it yourself, which, by the way, you can look up online and get the latest copy every day sent directly to you. But you really need to use other sources to do that because there's just not enough hours in the day unless your real job is to be the guru of Federal Register for your organization. So where can we get updates? Well, certainly, big companies have internal legal departments. The company I work for has, I think, 450 attorneys, and someone is assigned to different parts of the Federal Register every day. If it's an environmental law, then someone in the environmental law group goes in the Federal Register and looks under the table of contents to see what environmental rules, proposed changes, proposed rules, new rules, or public comment is open for environmental laws. And they would report that down to people in environmental health and safety so that they know something is coming or something has changed. But most companies aren't that big, right? The vast majority of people work for companies that are mid-sized or smaller. And a lot of them, if they are very regulatory intensive, have external law firms that do this research for them and report to them, on a regular basis, weekly, daily sometimes. Here's your daily brief on the Federal Register, and you can subscribe to those services. Trade organizations are very good at telling you about new rules, proposed rules, and public notices. So for those of us in the corporate security side, ASIS, I think, is probably the main trade organization that we belong to. And ASIS will send out notices, will send out bulletins, puts out a monthly magazine, and in it will be topics of new rules and laws and proposed rules. And you can stay current that way. Vendors and salespeople are an interesting sort because if you think of it this way, if something wasn't needed, then no one would sell it. It's needed by somebody, therefore we sell it. If a new rule or proposed rule or law is going to change the way as a security manager you must do your job, then some vendor in the security space has already found a solution for you and they will try to sell it to you. Now their solution may be great and it may be garbage, but they are going to alert you to the solution to the problem that you had not yet heard about. And I think a good portion of people in our field, and it's effective. It sounds strange, but you wait until you get invited to a seminar or a salesman calls you and said, hey, I'm now selling the new readers that are the proper height to mount on a wall, the back plate, the right lighting on them, whatever, to meet the new requirement in ADA. You had no idea that there was a new requirement in ADA to have a new type of reader or a back plate or a light or anything on it. But this vendor now wants to sell it to you because of a new law, a proposed rule, or a change that's coming. And therefore you get notified when they call to sell you stuff. You can also have the table of contents every day sent to you via email, and the table of contents is a one-pager. And you can scan through there to see if there's anything that applies to you, your business, or the security field in general. I know people that do that. I don't, but it is done. Just remember that laws change slowly, right? Very seldom do you see a law that just wasn't telegraphed months out. Even the executive orders that we see that are signed now, they're generally in the first few weeks of any presidency, you see executive orders. When the circle turns and Republicans are back in power, They will reverse the Biden decisions that just came out. And then when Democrats come back in, 4 or 8 years later, they will put them back in place. It really is a game of ping pong when it comes to policy in that regard. But they change slowly, and you know what's going to come. So you have time. Don't be concerned too much, when I talk about 60,000 pages of rules, proposed rules, and public notices in a year. You should be very cognizant of what is, very aware and informed about what changes may be coming in our industry. But don't obsess on it, because in most cases, you are not going to be surprised because things happen slowly. So here's an example. I cut and paste the language here. I have an email I received this past week, and it's an invitation to a live webinar. This one happened to have a cost for it, and it's nothing that really applies to me generally anyway. It does a little bit, but not that closely. But they're going to talk about compliance with Part 21 CFR, Code of Federal Regulations, Section 21 CFR Part 11, which has to do with the European Union's global data protection requirements on software as a service, right? So for those of you who are in cybersecurity, you know what all this means, right? Basically, if you are renting software, like maybe for a visitor system, or you have cloud-based video, or you're storing your video in the cloud, and you're getting video from the European Union, you have global data privacy requirements or regulations that you must abide by. And it says that people have the right to be erased. They have a right to see if you have them on video and they request to see it, that you have to give it to them. There's a whole lot of things that have to do with GDPR. This webinar, for 90 minutes, I can go and sit through it and listen to David Nettleton, whoever David Nettleton is. Never heard of him. I'm sure he's quite qualified. Certainly sounds it. But they will describe all this to me, and I will be caught up on 21 CFR Part 11. So the opportunities popped up. This came from a vendor. Again, someone wants to sell me a seat in a webinar having to do with a change coming to that particular Code of Federal Regulations part, and they let me know it. So don't get hung up on the fact that there's laws changing all the time, and there's new rules and proposed rules and public notices coming out all the time, and you can't keep up. Somebody's going to tell you in our field. You just have to keep your ears open and be willing to step up when you hear about these things to go out and get the information so that you can stay compliant. But really in this course, we're talking a lot about the judicial branch. And the judicial branch creates law in the form of decisions, okay, or opinions, cases, and they get published in case reporters. Now, just like the Federal Register, there are case reporters that you can subscribe to and you can read, and you could stay up on all of the judicial decisions of a particular day. But let's look at volume. In 2019, Supreme Court of the United States issued opinions on 63 cases. I have probably looked at all 63, not in great depth. Some of them I've read top to bottom. Others was like, oh, okay, that's what they decided. I do that because I'm a hobbyist. All right. But 63 cases. You will see in this class, if you read 2 cases in a week, you'll see that it takes you to read a case really well, a half an hour. Can you imagine if you had to read 63 cases in a year? So there's 30 hours. There's a full week, if you will, almost, of work time to read Supreme Court cases. The U.S. Court of Appeals had 47,977 filings in 2019. Now, you don't have to read all the filings, but there were opinions and decisions that came from those filings. And if you had to read those at a half hour apiece, now we're sitting at 25,000 hours. You have 2,080 hours of full-time work if you have a 40-hour a week job. And you have just used 10 people's time to read those filings. The FISA court, and I just threw this in here, which is the court for anti-terrorism, right? It's the secret court, if you will, had 1,000 cases by itself in 2019. And in the U.S., and 2006 was a year that just happened to pop up because it's indicative of every other year. Just look at the volume. 100 million cases filed. 54% of them were traffic cases. So let's just cut those in half. You wouldn't go and look for opinions on traffic cases necessarily, but 50 million court cases in the U.S. in 2006. And the U.S. has grown since 2006. The Bureau of Justice Statistics tells us that we would have to, if we wanted to stay absolutely current on everything in the judicial branch, we would definitely need to look at 50 million cases a year. Good luck with that. Enjoy yourself. I'm not helping. So the takeaway on that is that you're not going to be able to stay up on every case. Just as you do with the other branches, you're going to rely on someone to feed you information on those cases that impact you. And again, vendors and trade organizations in security are the best method to hear of these cases. You will hear if a case changes the way you must do business. Cases in the U.S. on facial recognition software are a great example of this. Over the years, people have filed lawsuits because facial recognition software, as good as it is for pulling people out of crowds, when you're scanning a crowd going into a baseball field or stadium, football stadium, and you're looking for people, 60 or 70 different faces, potential terrorists or bad actors. Facial recognition is very good for that. Facial recognition as an access software is a little iffy. When you walk up, a camera essentially picks you up, does certain manipulations of the distance between eyes and face and nose and all kinds of things, and then decides who you are and whether or not you should be allowed into someplace. It does not work well for people of color. It does not work well for those of Asian descent for the most part. It does not work well for those who are wearing religious head dress. It really is not as advanced as people think when you're trying to find one in, say, 50,000 in a database. However, when you're scanning a whole group, it does much better. So there have been many cases having to do with facial recognition software that have informed me as to whether or not I would use it in certain applications. I don't use facial recognition for general access in large volume facilities. You will not go to one of my facilities where people are coming in and there's maybe 1,000, 2,000 people, and it's being used to scan you into work rather than using a badge or a mobile credential or something else, because it is too unreliable in those regards. Now, when you only have 25 people that come and go, and it's only looking at 25 and it can make that decision much quicker, then I may use it. But court cases have determined that. And I got that from where? From trade organization articles and from vendors who told me they have the most reliable and it doesn't have these problems, which in most cases is not true. But I found out about those issues in those ways. Same way you find out, with the exception that you don't have the Federal Register, and even if you did, the volume of cases here is just too high. So common law is a term that you'll hear, and I wasn't sure whether you were familiar, so I think I'll go over it anyway. Common law is just another term for case law, decisions that are made on laws that refine that law. We are a system in the United States, we're a common law system. The law is expressed in an evolving body of doctrine determined by judges. So a law may be made that says that you cannot wear pink hats on Tuesday. And that is the law. And I come in to work wearing a pink helmet on Tuesday, and I am arrested because I am wearing a pink hat. A helmet is a hat. I go to court and I plead my case and tell the judge I wear this because I have a head injury and I must wear my helmet, or I could, in an unfortunate accident, if I bumped my head or somebody bumped into me, I could do permanent damage to myself. Therefore, I must wear my helmet. I only have one, and it is pink. And it was, special made for my big head, right? Picture me walking around in a pink helmet. Go ahead. The judge may then say, in this case, Brian is not guilty of violation of the law because, in his case, the pink hat was necessary for his own health and welfare. The law wasn't rewritten. We still have a law that says pink hats are illegal on Tuesdays. But Brian can wear his because there is a case that set precedent in the common law. It refined the law for exceptions. And that is where common law pretty much comes from. They modify the common law over time. So now someone else gets arrested for wearing a pink helmet. They go to court and they say, but the case found in Brian's case that pink helmets are allowed. Now that person was wearing a pink helmet because they rode their bicycle to work that day. It was a bicycle helmet, and they left it on. They decided they wanted to wear it all day because pink helmets are extremely cool. And the judge in that case said, but pink helmets, in the case of protecting you while you're riding a bicycle are only allowed while you're riding a bicycle. Now we have a law that says pink hats are illegal on Tuesday, unless you're wearing it while riding a bicycle and it happens to be a pink bicycle helmet, or anytime if you have a medical reason to wear that helmet. So over time, the common law just refines laws. Now, can you imagine if the law in Pittsburgh said you can wear a bicycle helmet all the time, but another Pennsylvania law said, no, you can't. You can only wear it while you're on your bicycle. You've got laws in conflict. Stare decisis simply means in Latin to stand by things decided. Be sure you watch the video that I put in this week. The professor from Cato Institute speaks very slowly, but he really explains this concept, and you need to understand this because it is the basis for understanding which laws will apply. If something has been decided, then a court often goes back to that other court. And if it's a court that's in their same area of jurisdiction, right? If you are a district court in California and the Supreme Court of California says something, then you will abide by it. But they may also look at what the Supreme Court of Idaho said. If California Supreme Court has not said anything, they can consider what the Supreme Court of Idaho has decided. And they said in Idaho, they decided that Brian could wear his pink helmet. And we think that that makes perfect sense here. And since no other higher court in California has ruled on this, we're going to accept the opinion of Idaho. And until California's higher court rules on it, that would then become the decided case. So understanding the common law as a way that laws are refined and then they're tailored to really fit the needs of the community, and that decisions are stood by, especially when made by higher courts, and often consulted or used even when there's a court that's not related to the one making a decision. It's how we try to make standardized these tweaks we're making to the laws, this refinement of laws. It's how we standardize it. So last week I talked about reading case law, and I gave you a very simple, start to take the names out, because I think that's something that trips people up. You can't remember who's who, because often a case may have 5, 6, 7, 8 names in it, and you forget, which one was the offender, which one was the victim, which one was a witness. But there's a lot of ways to read a court case that help make sense of the law. What we're reading are court decisions. We're not reading entire cases. We're reading the decision of the court. They have heard perhaps hours and hours of testimony, read volumes and volumes of documentary evidence, seen other artifacts, and from there they are making decisions. Sometimes the court decision really glosses over the case itself. It can be very annoying, and sometimes you have to go back and look at other documents. But they will just give the highlights of a case that they're concerned with. Okay, they're very narrow decisions in some case when they're changing and tweaking the law. And so they will go back and give a short explanation on the case facts, but they're more focused on the conclusion. There's distinctive parts in each decision that we read, and each one of them is going to be used when you write a legal brief for this course. But law students generally use the case brief method as an outline and as a way to help them in class. Legal briefs are not required. There's something called an amicus brief where you're writing on behalf of someone. There's a lot of different briefs that courts may require, but a legal brief is normally not required by anybody other than by a student or someone who's studying the law, so that they can outline a case and understand it better and simplify it and boil it down to its basic facts. You have to consider a case brief, the type that we're going to write, as like the Cliff Notes of legal reading, which is a good thing. You're not going to have to read the case more than once to figure things out. If you read the case and you write a brief, that will be your way to learn the facts of that matter. So the method that we will use will be a modification of the IREC model, which you read about this week. There were 2 different examples of this model. There was a longer version, and there was one with bullet points. Nice try if you thought we were going to do the bullet point ones, but that's not what we're going to do for this course, because it doesn't show full understanding to me that you understand each case and its intricacies and how the decisions were reached. But the general digested court brief consists of the issue, the rule, the analysis, and the conclusion. And, you're going to write a number of these for the remainder of this semester. It's going to be a significant portion of the discussions that we have, and we're going to modify it ever so slightly with an extra section. But they really help you boil down what a court case says. So let's go over each one of these sections first, and then we'll look at a quick example. So the issue. What's the question before the court? Don't let that fool you, because in many cases, the decision is based on several different questions before the court. First, was the evidence obtained in a proper way based on, rules of evidence? Second, was the jury advised correctly based on the rules of procedure? What's the issue before the court? There may be more than one. If I ask you to write a case brief, we'll concentrate on one issue or another. But it really is, what's the question before the court? What are they trying to figure out? Write it very simply. Don't try to write like a lawyer. I am not a lawyer, and many of you all know that. But I have written many case briefs for my own use because it is the easiest way for us to understand and to present to others what they must do differently and why. The rule. What's the law or precedent that the court's applying to it? So, basically they're just, you need to know what law they're really looking at, right? If you don't have a rule or a law to test against, then your opinion could be wrong. We're going to test it against this law. The law says you can't wear a pink hat on Tuesday. That is the rule that we are testing against. We may also test it against the precedent found in Idaho that says Brian can wear a helmet because of his medical condition. And then we're going to determine whether the person who wore their pink bicycle helmet around because they thought it was cool fell into that group. The analysis. Okay, how did the court use the rule to apply it? It's usually the longest part. You're going to tell us a little bit about the case in that and why the court reached a particular decision, which you list in the conclusion. What did they finally do? A lot of times they say we remand it back to the court which made the decision. We think you may have erred, but we're going to give you a chance to correct the error. They could completely reverse it, or they could uphold what the court said. And in many cases, and probably most cases, laws or decisions of lower courts are upheld because they've done it correctly. In our examples, in our case briefs, we're going to add an example to ours. This is strictly for learning purpose for this course, and you're going to make a tie-in as to how you might apply everything above, the issue, the rule, the analysis, the conclusion, what that might make you do differently as a security manager. And for that, I think we'll take a look at a case. So McGinnis versus Brinks, Inc. is the case for this week. It was in the reading. If you have not read it, then you need to stop here and go read that case from top to bottom. You need to understand the sections in the case, how the case is written, before you try to tackle a brief. So here we have a very simple modified IRAC version of a case brief. And so the first thing is you have to list the case. You have to tell us what you're talking about. Ronald McGinnis versus Brinks Incorporated, 1999, U.S. District Court, Part D in the state of Maryland. Okay? And that will come from the case. The top of the case will always have the title of the case, and that's what you put in there so that everybody knows which exact case you're talking about. In this case, the issue is a security company liable for the illegal usage of an issued weapon if it was used by a third party who was not actually issued the weapon by that company? Now, you've read that case and you understand what I'm talking about because if you've done the reading, as you should, this will make sense to you. If not, please go back and do it. Brinks issued a weapon to one person. That person lent that weapon to another, and the person they lent it to did harm to someone. Is Brinks responsible as the person who originally issued the weapon? The rule that was used, the Restatement of Torts, Section 390, 1965, and that says that an organization may be found guilty of negligent entrustment if the supplier knows the person will use the chattel in an unsafe manner that may cause physical harm to themselves or others. Again, when we read that, an organization may be found guilty of negligent entrustment if the supplier knows the person will use, in this case, the gun, in an unsafe manner. And from there, we go on to the second part of the case. So now we talk about the case a little bit in the analysis. McGinnis was shot and paralyzed by Ratliff, who was lent a gun. He lived with a Norma Jean Brashear. Brashear was issued a gun by Brinks. She was a driver messenger, right? So Brinks issued the gun to Brashear. Brashear lends it to Ratliff, who she lives with, and Ratliff uses the gun to shoot McGinnis. Was Brinks, the person who gave the gun to Brashear, responsible for the injury to McGinnis? The court considered that whether Ratliff was connected via contract or agreement to Brinks. Ratliff was not. Brinks had no idea that Ratliff even existed. They issued the gun to Brashear. Brashear lent it to Ratliff to hurt McGinnis. And in order for negligent entrustment to take place, the court found there needed to be a direct entrustment of the weapon. Right? Remember, we saw that in the rule. Negligent entrustment if the supplier knows the person will use the gun, in this case, in an unsafe manner. Well, there was no way Brinks could have known that. And what we say in the analysis is that in order for negligent entrustment to take place, the court found there needs to be a direct entrustment of the weapon from the owner, which is Brinks, to the person causing the harm, Ratliff. Brinks entrusted the weapon solely for the use of Brashear, so there's no way they could be held accountable for Ratliff's actions. So what was the conclusion? Well, the court found that the Section 390 didn't apply to Brinks because the weapon was not used by the person issued the weapon for use by Brinks. Okay? The Restatement of Torts, Section 390 of 1965, holds suppliers liable for damages or injury caused by persons to which a chattel was supplied if they are aware that the misuse, if they're aware that that issue may result in a misuse. Brinks wasn't aware of it, nor could they have predicted that Brashear would lend the weapon to her friend because they didn't even know the friend existed. Now, Brinks would be very smart to be sure they have a policy in place that says your weapon is your responsibility, and I'm sure they did in this case, right? But the liability doesn't extend to a third party, and as such, Brinks was not found negligent. This makes perfect sense to me, this case. I think the decision is a very sound one. But what does that teach us, really? And from an example standpoint, for me, it tells me that if I'm a security manager and I'm using contracted armed guards, which Brinks provides, I'd make sure my contract has a very specific and comprehensive clause that protects me from the actions of the guard with weapons during their off-duty time. I would want Brinks to have in the contract with me that they are fully responsible for any misuse of weapons unless they happen during the work hours and it can be shown that my policies allowed it to happen. In fact, I would probably consider, as a security manager, using a company that makes sure that at the end of the shift, the weapons are turned into an armory somewhere and locked down and not available off hours. I don't know any security company in their right mind that would allow people to take their weapons home with them, although it happens all the time. But why would you do that? If at the end of the shift you say, on your way home, your shift ends at, you work 12 to 8, and at 7:30 you leave your post and you drive to the office and you come in and we have a clearing barrel, you clear your weapon, you put it in the armory and you go home and you pick it up the next morning. Pay the extra half-hour tag time on either end of the shift for weapons issue and weapons security. That would be the examples that we will add. So in our sections, we are going to have the case name, the issue, the rule, right? The analysis is the part that you really write yourself because the rule is going to be in the case and you're just going to cut and paste the rule. The issue, once you read the case, you'll know what the issue is. You'll do the analysis. You'll tell us what the court concluded and why they concluded that way. And then you're going to give us an example as a security manager. What does this tell you? What does it teach you? Where can you apply this in your practice? So McGinnis v. Brinks is available. The example that I gave is available in your packet. But as you saw when you read the case first, there was more than one question before the court. And later on, we will study McGinnis v. Brinks again, but from one of the other questions that was the court had. And so if you didn't read it, you're going to read it anyway. So how are we going to use this in our course? Okay, for all the cases we review in class, there will be case briefs prepared by you. Now, we may read 3 or 4 cases in a week. And rather than have you prepare 3 or 4 briefs, I may have you prepare 1 or 2, and we'll break the class. So if there are 8 cases discussed in a week, then I'll probably have a quarter of the class working on 2 of them, another quarter working on 2 of them, another quarter, and we'll mix it up quite a bit. So you won't be in the same groups the whole time. But that way we can get a vast number of cases done in the time we have allotted. We'll have exposure to more cases, but you're responsible for knowing all those cases. Now, we're not going to have a law school type exam where I say, this happened and that happened, which case is this from? But if everybody is writing, let's say we have 8 cases in a week and you're writing 2 briefs, you should know those 2 cases cold. And when you go into the discussion board and read up on the others, you will read 1-pagers on each of those other 6 cases. So you'll have exposure to 8 legal cases by reading 6 briefs and preparing 2. So you have a responsibility to each other in this course to write a very well reasoned, very well written 1-pager, because that's what they are, legal brief, so that other students can learn from it. If you write a lousy legal brief, they won't learn from it, and you're not doing them any service at all. Hold up your ending of the bargain of being in the class. So let's recap a little bit. Laws come from administrative, legislative, and common law sources. Common law sources meaning case law. States have police powers. They can enhance laws to allow for their own norms and customs, and it's not just states. It's states, counties, cities, other municipalities, townships, boroughs, what have you, can all put their unique spin on a law, so long as they don't go outside the confines of that law. Now, the Federal Register is the official reporter of legal change at the federal level, and it warns us of potential changes, new rules, proposed rules, and public notices. It is a very long and boring document, quite frankly. 132 pages in one day. Some are longer, some are a little shorter, but I don't think I've ever seen it go below 100 pages. You have to have ways of staying current on that, and it's not to read 130 pages a day. It's to primarily concentrate on vendors, because they will bring products to you and bring information to you based on these changes, and because they want to sell you something normally that helps you with that change. You don't necessarily have to buy, but you will be informed. And trade organizations, trade magazines, trade articles, newsletters will also give you that information. I suggest you be active in those organizations because it is one way to stay current on changes. Remember, the law changes slowly. It gives us time, so you don't have to obsess on it, but it is your responsibility. Courts are really busy places. 102 million cases in the United States in 2019. Or that was 2006. I apologize. I will find a 2019 stat for you, but when I pulled down over 100 million cases, I think you get the point. You're not going to read all those cases. There's an opportunity for common law adjustment all the time. Any one of those courts could make a decision that hasn't been made by somebody above them before, and it becomes the precedent, quite frankly. But it's more common at the appeals court and Supreme Court, state and federal Supreme Court levels. Those are really where the big changes and precedents are set that allow us to modify the law to allow for our own judgments and exceptions. The concept of stare decisis, it really sets our common law. Okay, it allows for the reasonable and incremental change, but it doesn't allow for it to go without some sense of order. If something has been decided by a higher court, the lower court will yield to it, right? The decision has already been made, and we yield to those decisions. A great way to understand a case is to brief the case using the IROC method, and we're going to add our example on there so we can show that we're taking something away from it toward our corporate security careers. But you will be certainly writing briefs. You won't do one this week. This week is a quiz week, but you might want to get used to how to do that and start to practice a little bit, at least in your mind, how you're going to do it, because next week you will be briefing cases. So this week you had the lecture, which you just finished. Thank you very much for your attention. You're at 44 minutes. The reading, some has been provided. There's reading and viewing. There's a little video in there as well. And there is reading from the text, and that is the McInnis v. Brinks case. You really do need to read that case to understand the several questions that the court asked. We only briefed on one, and when we do our briefs, I will give you generally which issue before the court we're going to brief on, because there could be different, a lot of different factors in one case. There's a quiz this week. It is due on Sunday at 11:59 p.m., as our quizzes are. It is not an easy quiz, so make sure you don't try to sign in at 11:56 and give it a shot, because you will not do well. There are 5 remaining discussions in the course, 5 weeks where we have discussions. And then in the end, we will be doing some exercises where we have a Zoom meeting with groups, and you'll set up your own groups. I will set the groups, but you'll set up your own times for that and make it convenient for everybody, or we'll move you to different groups where it is. But the majority of that work will be done as legal briefs. So you need to understand this process. I will be on office hours Wednesday on Zoom. I will shoot this class as well, the Zoom meeting number. If you want to drop in Wednesday, my office hours are 6 to 8 on Wednesdays and Saturdays from 9 to 11. On Wednesdays, I hop on Zoom, but I'm available to you. If you don't understand how this is done, you need to speak up, because we're going to jump right into it in week 4. So with that, the lecture is done. The reading you need to do, if you haven't done it, hopefully you did it first using the suggested order of operations. Take the quiz. Don't forget the quiz. There are people who forgot the last quiz, and there's no makeups. So get on it. With that, have a great week. I'm available to you, and I will see you on campus.